Hi, folks. It's Andy Stautz with Stautz Law. I am back for another general informational video about Indiana law. Today, we're talking about testamentary trusts, specifically your choice of trustee, choice of fiduciary for your testamentary trust. So, I've recorded lots of talks about how testamentary trusts work, what they are, but basically, it's a trust that you create in your will. So the trust doesn't exist until the will is probated. Now all of a sudden, okay, we've got a trust. Just like for any other trust, you need a trustee. That's the person who is in charge of carrying out your instructions. And the choice of trustee is really important. Really important, okay? Because you can put any instructions you want in a trust. Just about. I mean, within reason. But you can get as creative as you want in the drafting. You can write any rules you want. You can make it complicated, wish lists, go crazy. But push comes to shove, a trust only actually works, legal validity aside, a trust only actually works, only does what you want it to do if you've got a trustee who's going to carry out your instructions. That's just behavioral hard truth. I mean, you can't make something happen unless the trustee does it for you. So you want to get it right. You want to choose a trustee who understands what the instructions are and is going to carry them out, and that you can count on. So the trend, and it's been an ongoing trend since long before I was in practice, is to have like individuals, family members, friends, etc., serve as trustees. Okay, because I think this has to do with like bank consolidation and the loss of trust departments and increasing, fees and requirements. So for many people with a small estate planning trust, right, they're not going to have a big bank handling it for them. They're going to name a family member or a friend. And as we've discussed in the past, that introduces behavioral risks, right? Because you need to make sure your trustee knows how to do the actual work of being a trustee, like making accountings, right? Keeping an inventory, reporting to the beneficiaries if they need to do that. Actually has the financial and administrative savvy to carry out the trust instructions. The second point is, you need to make sure it's someone whose interests align with your interests as regards the trust. So, you don't want a situation where the trustee is tempted to commingle funds or to apply trust funds to benefit his or her own life, etc. And a common scenario here is, okay, what about the parent of a minor? If the parent of a minor is a trustee for that minor, they're constantly going to be facing decisions like, okay, do I use my own money to pay for, childcare expenses, etc., or can this be a trust distribution? Can I use trust money? And that's, maybe it doesn't make a difference, right? But it's something to think about. Do you want your trustee to be in a position where they make that choice or face that temptation? So especially for testamentary trust, where the trust doesn't have any history or pattern, it just comes into being once you're gone. You need to be especially sure that your trustee or the person you're thinking about naming as a trustee is going to accept the appointment, is going to know what to do, and isn't going to face conflicted decisions often or all the time about how to follow your instructions. So this is not a realm of legal certainty, right? This is a discussion about values and people, and it's very case by case and specific. So I realize it was general talk, but it's one of the things we'll talk about if you come to me for your estate planning, and it's one thing you should definitely be talking to any attorney about if you're in a place where you're making a testamentary trust or considering one. So I hope that's been a helpful overview. You're on my website. Give me a call, give me an email, and we'll set up a time to talk about your specific facts. Hope that was helpful, and bye for now.